Hello and welcome to AWCI's webinar, Workplace Violence Prevention Plan, What You Need to Know. My name is Tam Nguyen, AWCI's Education Program Manager. Before we start, a few housekeeping items. All attendees should be on mute during today's presentation. And should you have a question at any time during the broadcast, please submit it using the question box in your GoToWebinar dashboard. We'll have a short Q&A session at the end of the presentation. At this time, I would like to introduce our presenters, Rachel Kahn and Andrea Chavez. Rachel is the chair of Kahn Maciel Carey's California practice. Her practice has a special focus on occupational safety and health compliance and litigation. Andrea Chavez is a senior counsel in the Los Angeles office of Kahn Maciel Carey. Her practice focuses on California OSHA labor law, California employment law advice and counseling, and complex employment litigation. So at this time, welcome Rachel and Andrea.
Thank you, and thank you for having us. And as mentioned, this webinar is on the new California law regarding workplace violence prevention, SB 553 as it's known. It is a very complex onerous law for employers. Andrea and I have been doing a lot of work in this space for many years, specifically, pre-SB 553, we've been doing a lot of work and have been doing so since then. So we're happy to be here with you today to go over, what to expect. As mentioned, I'm a partner and chair in the California practice, and I specialize in occupational safety and health, and particularly Cal OSHA compliance and litigation. And I'm joined today with my colleague Andrea Chavez, who's a senior counsel. I'm in San Francisco. Andrea is in Los Angeles, and we both do lots of Cal OSHA work. Andrea also specializes in employment work as well. And as you will see, as we go through this presentation, you'll see that, one of the components of this is that it's not just a safety and security issues that arise when you're complying with this law. There's also a lot of HR and legal issues to consider as well. So that's why having a very holistic approach to compliance is important, and we'll emphasize that throughout today's presentation. So the agenda for today, we'll just briefly talk about what kind of the law and framework look like pre-SB 553. So for those of you that maybe didn't get a chance to follow it as carefully, SB 553 was adopted in October of 2023, and it goes into effect July 1, 2024. So, but workplace violence prevention has been on the agenda for Cal OSHA for many, many years. So we'll kind of walk you through that history briefly, because I think it's important to kind of frame where we are now. Of course, we'll go through what the final bill is, what your requirements are going to be for compliance, and then the status of the Cal OSHA regulation. This, SB 553 is a statute, a law that was promulgated by the California legislature, but it also requires that Cal OSHA continue to rulemaking on its own regulation. So this is not going to be, this bill is what you're going to have to comply with by July 1, but we're going to see some additional tweaks and requirements from employers in the next couple of years as well. Andrea is going to walk us through the implications for employers. As I mentioned, like most laws, it doesn't sit in a vacuum. So you're going to have to comply with this statute, but because we're talking about employee safety and health, it touches on some other employment laws that we want to make sure that you're aware of. And then if we have some time, we'll talk about SB 553 also amended workplace violence restraining orders here in California. So to the extent that that is something that you utilize as part of your workplace violence prevention, there's been some changes to that, and we'll briefly go through that as well. So why is workplace violence in California? Why has this become such an issue now? Per the Department of Industrial Relations, which is the department that Cal OSHA rolls up into, workplace violence includes, threats or acts of physical violence at work, and is a serious concern for employers and workers. And the latest data, this was the data from 2021, there was 57 people that died from workplace violence at work. And that doesn't include the US average of 1.3 non-fatal crimes in the workplace. So certainly there's been a rise in workplace violence in the state, but also in the country overall, and fatalities being in that. For those of you that are located in California, you'll know that we had last year or the year before several mass shootings and places of employment. There was Cal OSHA citations that were issued as from both of those. And so it's definitely something that California has been focused on. And, one of the bright lines that I will say from this law is that it does at least give some prescription to employers about what is required of them here in the state. If you take a look at the citations that were issued by Cal OSHA in some of the mass shootings that recently happened, those were issued under the Injury and Illness Prevention Program, which is what we have here in California, which is kind of our general duty clause, kind of catch-all piece. And those citations were kind of all over the place in terms of what they required employers to do. So I think, I think in some respects, this at least gives you a framework that you know that you have to work within. So pre-SB 553, what did that framework look like? We have had a workplace violence prevention standard in healthcare since 2017. And, Andrea and I have worked with employers a lot in their compliance with that regulation, as well as defending employers in citations related to that regulation. And the original bill that was SB 553 was actually based on this healthcare standard. Now, luckily, it got pulled back, and it's not quite as onerous as what's required for healthcare, but that was originally the starting point for it. Again, pre-SB 553, workplace violence was regulated under the Injury and Illness Prevention Plan program here in California, which requires all employers to evaluate any hazards in their workplace and train on those hazards. So Cal OSHA would tell you employers have always had the requirement to assess and prevent workplace violence under the IIPP. As I also mentioned, SB 553 and pre-SB 553, we've always had workplace violence restraining orders here in the state. So for those of you that are not familiar, here in California, the employer can petition the court for a temporary restraining order or a permanent restraining order on behalf of an employee. And so that is a tool that a lot of employers do utilize, and that's always been available. There's also been different ANSI and different standards, industry standards, that employers have been able to look to for workplace violence prevention and response as well. Those have been out there and been available to utilize. So SB 553 really did three different things. It amended the California Civil Procedure Code to amend workplace violence restraining orders. Again, we'll talk about that a little further if that's something that you utilize. It also amended the IIPP statute, which is in the labor code. And it now requires, as part of your IIPP, that you have a workplace violence prevention plan that conforms to the requirements of Labor Code 6401.9. So again, now as part of your IIPP, as an element and as a requirement, you have to have a workplace violence prevention plan conforming with this new labor code. That was the third part that was added to SB 553. And that's where the requirements for workplace violence prevention now sit, which we'll get into in a second. So SB 553, and you know, a little bit more background. In 2017, Cal OSHA issued a workplace violence restraining order, workplace violence prevention regulation in healthcare. After that, they began rulemaking on one for general industry, and they released a draft. We had some advisory committees on it. COVID happened and kind of pushed that out of the way for a while. In early 2023, the California legislature got a little tired of waiting for Cal OSHA to finish rulemaking and essentially leapfrogged Cal OSHA and said, if you're taking too much time for this, we're going to go ahead and have a statute, pass a law that requires this of employers. And so at the end of the day, the statute actually looks a lot like the Cal OSHA draft regulation. And as part of the statute gives Cal OSHA authority to enforce it and requires them, again, to rulemaking. Now, all of the requirements that we're going to talk about today are going to have to be in place by July 1, 2024. And the changes to the workplace violence prevention restraining orders don't go into effect till 2025. So one of the things to start with the new labor code where the workplace violence prevention requirements sit is there are some exceptions to it. So it's a general industry standard, meaning it applies to everyone with the following exceptions. Of course, if you are subject to the Cal OSHA's violence prevention and healthcare standard, you won't be subject to it. If you, California Department of Corrections and law enforcement agencies are not subject to it for obvious reasons. If you have teleworking employees that are teleworking from a place of their choice, they are not subject to it. And if you have workplaces that are not accessible to the public with less than 10 employees, they are not subject to the law, except unless you still have to comply with the IIPP, meaning that in those workplaces that are not accessible to the public, there's less than 10 employees, you don't have to per se meet all the requirements of SB 553, but you still need to be evaluating workplace violence hazards, have some sort of program in place and training on those hazards under the IIPP. So you're not off the hook totally. So one of the really important things that, before we kind of jump into what you're required to do, one of the really important things that I like to flag for employers is that the definitions of workplace violence under the statute are very, very broad. And they're not exactly what we typically think of when we think about workplace violence. Most people, when we're thinking about it, are thinking about physical violence or threats of physical violence. But workplace violence is not limited to those things under the law. It also includes anything that could result in psychological trauma or stress, regardless of whether or not the employee sustains an injury. So that's a pretty broad definition. And one of the reasons why I want to flag that for you is because when we're going through the requirements, one of the things that you will be required to do is maintain a violent incident log and investigate every incident of workplace violence in your workplace. And that's going to include things that may cause psychological trauma or stress to your employees. So as you can imagine, that may significantly increase the amount of potential incidents that you have in your workplace. Obviously, anything that involves a threat or use of firearm or other dangerous weapon would be considered workplace violence. They also include in here the use of common objects as weapons. That's a holdover from the healthcare standard, where you may see things like in a healthcare setting, patients grabbing things like pencils to attack employees with. So I think that you would probably see less of that in general industry, but Cal OSHA would consider things, ordinary everyday objects that an employee may use to injure another employee, or it's not limited to employees. If you have a customer or you have somebody from the public that is using a common object to assault an employee, that's going to obviously fall under this. A threat of violence is also any verbal or written statement, and this is going to include text, electronic messages, social media messages, online posts. So as you can see, again, that's a pretty broad universe, and kind of gets into areas where, as employers, we try not to tread as much. But certainly, if you have an employee threatening other employees over social media, that could trigger requirements for you under this law. So we just want to be, make sure that you're aware that there's a lot of different components that are happening here. And because of these broad definitions, you're going to really have to pay attention to what's considered an incident and what is not. And one of my recommendations for employers off the bat is, as you're developing your plan and as you're developing your program, to really, with your team, determine, okay, these are the types of incidents that we think fall under the definitions, and these are the ones that don't. You don't want to wait till you're in the middle of a potential incident to start to consider, does this fall under the definition of workplace violence or not? So the statute also includes 4 types of violence. And this is, the reason why this is in here is because this is part of how you're going to have to log your violent incident log. You're going to have to include one of these different types as part of that. And there's not a whole lot of controversy around these different types. They're pretty much generally accepted within the workplace violence prevention and response community. These are kind of the standard different types of violence. However, they might be ones that, as an employer, you really maybe haven't been used to having an obligation for or working with. So the first one is, essentially anybody that comes into your workplace to commit a violent crime. So type 1 is really third-party acts of violence, criminal acts. And what I think is interesting about this is because, for most of the, history with OSHA, these types of acts, these types of incidents have really been considered unforeseeable and not really, employers really haven't had an obligation for these third-party criminal acts. But here, Cal OSHA is bringing that into the fold, and there are things that you're going to have to consider as potential hazards to your workplace. So there are things that may not be in the realm of things you've considered in the past. Type 2 and type 3 are ones that, you've probably most used to dealing with or, being aware of. And type 2 is, violence that is directed to employees by customers, clients, patients, students, members of the public, or people that may come into your workplace that are employees. The third type is employee to employee violence. And then the fourth type is probably the one that employers probably feel the least comfortable dealing with. Although this is the one, and I do a lot of workplace violence work. I sit on a lot of threat assessment teams, and this is the one that I probably see come up with the most frequency lately, to be honest with you, and certainly a rise in it. And it's violence that's committed in the workplace by someone who does not work there, but that has a personal relationship with the employee. So, we're usually in this, we're talking about domestic violence, intimate partner violence, stalking, that is really a catalyst that has developed outside of the workplace, but has the potential or is spilling into or creeping into the workplace. So again, this is one that really is a hard one to deal with because it's really very personal to your employee, and one that maybe because of that personal nature, employers haven't really dealt with, but now becomes part of this universe of workplace violence prevention. So we've talked a little bit all about this in kind of this broad concepts. So what does SB 553 require of employers? So it requires you to establish, implement, and maintain a workplace violence prevention plan. And in a minute, we'll get into what is required to be in that plan. And there's 12 elements to it. So off the bat, you will have to have a workplace violence prevention plan, number one. And one of the things that you need to keep in mind, and it's Cal OSHA's favorite word, and it's in the statute as well, is that your plan must be effective. And what does effective mean? It means that it's not enough just to have a great, beautiful plan in place with all these wonderful policies. It actually has to work. It has to be operational. So if you say, this is how you report an incident, this is how we're going to respond, that needs to work, and that needs to be effective. So as you put together your plans, keep in mind that, is this actually going to work? Just don't, make sure you're incorporating the people that need to be a part of this, that can give you the feedback as to whether or not this is going to be operational. Now, this plan can be a part of your IIPP or a separate document. Our recommendation is to maintain it as a separate document. You're also going to have to evaluate your workplace for workplace violence hazards and potential hazards. You're going to have to maintain records of that, and you're going to have to maintain records of any corrections, abatement that you do as part of that. You're going to have to investigate any workplace violence incident, and you're going to have to maintain records of that. As I mentioned before, you're going to have a violent incident log. And what that is that it's going to look a little bit, it's sort of kind of akin to a 300 log, but for workplace violence incidents. And the statute, and Andrea will talk about that in a minute, is going to provide to you exactly what needs to be included in that log. But for every incident, you're going to have to log it and maintain it. And there are record keeping requirements for all of this documentation. And so, anybody who has dealt with Cal OSHA knows that documentation, employers not maintaining correct documentation is a favorite citation of them. So you really want to make sure that you understand your documentation requirements and you're maintaining them in the way that Cal OSHA requires. And then, of course, there's training. Employees have to be trained at the inception of your plan and then annually thereafter, as well as any time that there's an additional workplace hazard. Now, for workplace violence. Now for those hazards, that just has to be, just on those, you have to do the whole retraining, but that's still a significant training lift. And also the training has to be interactive. And Andrea will get into those requirements a little bit later, but that's a lot of pieces. That's a pretty heavy training obligation. So again, you're going to have a plan, you're evaluating and correcting workplace violence hazards, you're maintaining violent incident logs and investigations, and you're training your employees. So as you can see, there's a lot to do prior to July 1. Go into some of the elements of the written plan. And some of these, it's very, if you're used to putting together written programs as part of, for Cal OSHA generally, a lot of what you're going to see here is going to be familiar to you. It's kind of follows a similar rubric and framework that we normally see for Cal OSHA. So you're going to have the names and job titles of persons responsible for implementing and maintaining the plan. And this really has to be specific to what their responsibilities are going to be under the plan. So, that's not too surprising of an element, but you're going to want to think through, are there going to be people at corporate level, at the site level? Is HR going to have some of this? Who's going to be doing what, and make sure that you're really getting that right in your plan. You're going to have effective procedures to obtain active involvement of employees and unions. So this is for implementing your plan, investigations, for implementing training. You have to have procedures to be getting feedback from those folks. So if you have safety committees, that's always a great way of going about doing that. But if you don't, you're really going to have to brainstorm about, how are we bringing folks into the fold? And the reason that Cal OSHA includes this requirement, and I know this is a bill, and I say Cal OSHA because that's where the draft of their regulations was really kind of the baseline for this. But the idea is that employees on the ground are going to be the ones that are going to really have the most kind of potential knowledge of what the workplace violence hazards are in their workplace. So that's why, this element exists. And one of the things that I, also wanted to add about your plan overall is that the statute requires that it be specific to your work operations and to work areas. So you can't just have a blanket plan for every facility. You really have to evaluate each facility and the potential hazards of those facilities. So your plan also has to include methods employers will use to coordinate implementation of the plan with other employers. If you are in a multi-employer work site, you have to be coordinating your plans with those other employers. You also have to have procedures to correct workplace violence hazards identified, and effective procedures to accept and respond to reports of workplace violence, and to prohibit retaliation against employees who make them. Procedures to ensure that employees comply with the plan. That's pretty similar to probably what you already have in your IIPP. Procedures to communicate with employees regarding workplace violence matters. Again, a little similar to what you probably have in your IIPP already. Have to have effective procedures to respond to actual or potential workplace violence emergencies. Procedures to develop and provide training. Procedures to identify and evaluate workplace violence hazards, including periodic inspections. Now, these are the periodic inspections is something that can probably be included in your periodic inspections that are required under the IIPP. So you can probably kind of combine those together, but you are going to have workplace violence specific considerations there. Procedures to correct workplace violence hazards identified and evaluated. Procedures for post-incident response and investigations. that's always a place that you probably are going to want to incorporate HR or those that are in equivalent roles, and procedures to review the effectiveness of the plan and revise it as needed. This has to be annually reviewed. And that is certainly an area that we know that Cal OSHA loves to hone in on in other plans that require this. So I definitely want to flag that for you as one that you want to ensure that you're hitting as part of your operational component of this. And with that, I'm going to turn it over to my colleague Andrea, who's going to walk you through your violent incident log. So again, that's your requirement for your plan. You must have the written plan, and Andrea is going to take us through the other requirements.
Thanks, Rachel. So yeah, as Rachel just said, she just went over the elements of your workplace violence prevention plan. But beyond that, you must maintain a violent incident log in which you record information on every workplace violence incident in California. So if we go back to the definition of workplace violence, you'll remember that it's a very broad definition, and there are a lot of things that can be considered workplace violence, which you're now going to have to investigate and log. So as you see here, SB 553 requires the log to include a lot of information, including the date, time, location of the incident, a description of the incident, a classification of who committed the violence. So that'd be, was it a customer? Was it a family member of an employee, a stranger? A classification of circumstances at the time of the incident. And SB 553 gives examples to include, like, was the employee completing their usual job duties? Were they in a poorly lit area or working during like low staffing levels? Another element is a classification of where the incident occurred, which would be, you know, was it in a parking lot? Was it outside? Was it on the floor of the store? And then the type of incident. So was it a like physical attack with a weapon, without a weapon, a threat of violence, a sexual assault, something like that. And then the consequences of the incident, which means, you know, what happened after the incident occurred. Was law enforcement called? What steps were taken? And then actions taken to protect employees from a continuing threat or from any other hazard identified as a result of the incident. And then finally, information about the person completing the log. Now, one of the things to think about is that for each of these incidents, an investigation also needs to be conducted, and then an investigation report needs to be filled out. So the most efficient way we think to do this is to streamline the process, make sure that your investigation report and the questions on there have all the information you need to complete the log. Another thing to think about is, you know, who's going to be responsible for conducting the investigations. As we said, the definition of workplace violence is really broad. So there may be circumstances where you want one team handling, you know, one kind of less significant incidents and another team handling more significant incidents. So those are all kind of things to think about. You have your plan, now you have to train your employees. An initial training needs to be provided when the plan goes into place, and then annually thereafter. You also have to do additional trainings when there is a new or previously unrecognized hazard or when there's a change to the plan. But these additional trainings can be limited to the new or unrecognized hazard or the change to the plan. So let's say an employee is walking home late, gets, you know, an incident occurs, and then the plan is changed to implement a buddy system. Your additional trainings can just be about that new unrecognized hazard and then the buddy system. Employees must also have the opportunity for interactive questions and answers with a person knowledgeable about the plan. Interactive in this context is undefined still, but we can take some guidance from other training requirements from Cal OSHA For example, there's the blood pathogen training requirement, which essentially says that the questions that employees have need to be answered immediately. So, I think that would be the most conservative approach to take here, but it's unlikely, at least in the beginning, that Cal OSHA inspectors are going to be consistent with what they consider to be, sufficient to satisfy this requirement. And we also know that, large employers or just employers in general rely often on computer training modules or on-demand training. And, in those circumstances, again, we think the most conservative approach would be to have someone available basically at all times or at any time an employee can be taking one of those on-demand trainings to answer employee questions. Okay, so here's a list of the topics that employees need to be trained on. For national employers, some of these topics will be covered in their national, workplace violence and emergency action plan trainings. However, there are certain SB 553 training requirements that are unique to California. So it's important that even if you have a very expansive national training already in place, that the California employees get a California specific supplemental training to fill in the gaps. And some of those things that the California training would cover definitely would be, like the definition and requirements of this specific law, how to the violent incident log and how to obtain copies, things like that. Okay, so moving on to record keeping. Now this one is very cut and dry, and this is why Cal OSHA loves to issue citations for record keeping. We see a lot of players get citations for this and get repeats for this. So, maintain records for hazard identification, evaluation, and correction for 5 years, violent incident logs for 5 years, training records. You're required to maintain them for 1 year, but we suggest maintaining them for longer than that, at least 2 years, and maintain incident investigations for 5 years. So it's important to remember also that records maintained for items 1 through 3 must be made available to employees and their representatives upon request within 15 calendar days. And then the incident investigations have to be provided to Cal OSHA when it's requested. So something to think about. You want to make sure that you're providing the required information and the information is accurate while also taking into account the employee privacy. So for example, the log, even though it requires a lot of information, it's unlikely that the entire contents of an investigation file should just be regurgitated onto the log. And then for the investigation files themselves, there may be situations where you have a privileged version of an investigation file and an unprivileged version. So also there's a lot to think about there. Okay, so Cal OSHA is still in their rulemaking process for their the general industry standard. And they are now required to propose a regulation to the standards boards by the end of 2025. And the standards board is required to adopt a rate of 2026. We know Cal OSHA had approval, but they allegedly are going to go through another advisory committee meeting in light of SB 553. So stay tuned on that. Okay, so now I'm going to go over some of the concerns about implementing a workplace violence prevention plan. When implementing this law, you'll find that it intersects with other areas of law, such as employment, workers' comp, common law, privacy law. For example, SB 553 says that investigation reports cannot contain medical information. However, medical information is very narrowly defined and essentially includes records from a medical professional. But there's going to be a lot more information that you collect during these investigations than just quote unquote medical information. You're going to be gathering, information about domestic abuse, mental health issues, possibly past criminal activity. So it's important to figure out what the law is regarding gathering that information, who should be privy to that information, how it should be stored, and how it can be used. And another important thing is to remember that employees have a right to be free from unreasonable invasion of privacy. So when you're conducting these investigations, it's important to think about whether, the information you're seeking is actually relevant and pertinent and is needed to make a decision on how to move forward. Another concern is that SB 553 is new, and we don't know exactly how Cal OSHA is going to interpret it. So, for example, the plan has to be specific to the hazards and corrective measures for each work area and operation. And honestly, we just don't know yet what level of detail will be considered sufficient to hit that requirement. Okay, so here's a list of some of the other intersections with law that you should be aware of. I'm not going to go over all of these. We already kind of touched on some of them, but one I would like to point out is the intersection with discrimination laws. As you all know, all workplace policies should be applied equally to all employees, regardless of their protected characteristics. And the same goes for implementing SB 553. And, we've mentioned multiple times now that the definition of workplace violence is expansive and includes things like threats likely to cause stress to employees, which really gives a lot of room for interpretation to employers. So it's just important for employers to set aside any preconceived notions about who might commit acts of violence and who is or isn't vulnerable to psychological stresses when assessing the incidents and determining disciplinary action. And one example where we see this is the idea that, sometimes men may commit more violent acts than women and are less likely to suffer stress from possible threats than women. So meaning, that their complaints may be treated differently, and their complaints themselves about workplace violence may be treated differently, and then their acts of violence may also be treated differently. And doing that may lead to a discrimination claim. Okay, so I just want to touch on this quickly. Under common law, employers have a special relationship with employees, giving rise to a duty of reasonable care. Companies also have a duty of care to third parties that enter their premises. So that would be like their clients and customers. So you want to just make sure that your conduct rises to that level of care. For employees, injuries resulting from workplace violence will usually, their injuries will usually be covered by workers' comp, and that's typically regardless of fault. There are some exceptions to this rule. For example, when the employee's injuries result from the willful physical assault by an employer, or such actions that were ratified by an employer. And in those cases, the injured employee can pursue claims and get damages in civil court. So, we just want to make sure that you have the right procedures in place to protect your employees and your clients, and SB 553 is a part of that. Okay, so moving on. As you see here, we're kind of going back to the idea of what you can and cannot collect on employees. And we just wanted to give you some examples of these laws. I'm not going to go into depth about these. We could do a whole another hour on them, but just be aware that if you're, for example, collecting information on criminal records, there are laws that restrict what you can collect, what it can be used for, and how it is collected in California. And California still putting out these laws. So this is still a developing area. For example, just this year, there's new constraints around marijuana convictions. There's constraints about public record searches, social media searches. So we just wanted to flag this for you. You should really consult with an attorney before, conducting such searches during an investigation. And so with that, I would just like to reiterate something that Rachel said earlier, that in developing and implementing your workplace violence plan, it should not be done in a silo. Management should work with HR, legal, your safety team to ensure that you have a plan that is functional and legally compliant. Okay, so now I'll pass it back to Rachel to discuss workplace TROs.
Andrea, and again, just to reiterate what Andrea has said, that really this is a holistic approach. Unfortunately, when the legislature and when Cal OSHA puts out these types of laws and regulations, they don't think about all of the other, employment laws and things like that that might be implicated. So again, certainly this is not just a issue for EH&S. This is just not an issue for security. This is something that, if you have HR partners, you want to be involving. If you have legal, you want to be involving. It's really a team sport to ensure that you're doing compliance. And before we get into the TROs, which is kind of a little bit of a separate issue, I just want to make sure everyone has some really clear idea of what's the requirements under SB 553. And I apologize for keep repeating this, but in talking to lots of different employers, the feedback I'm continuing to get is that, we've read up on it, we've talked to people on it, and there's still confusion about, what is required, what employers need to do. So again, one, you're going to have a written plan that includes all of those 12 elements that we went over today. That is going to be the cornerstone of your program. Everything's going to flow from that plan. So number one, you need a plan. Number two, part of that is you're going to be evaluating potential workplace violence hazards in your workplaces. So you're going to be doing that. You're going to have procedures for that as part of your plan. And then when you have those components, you're going to be training on it. So you're going to be training on your plan. You're going to be training on what are the potential hazards and all of the other things that Andrea talked about. You're also going to have record keeping. Your record keeping your violent incident logs, your record keeping your investigation reports, your inspection reports, your plan, your training records. So those are all of those components that I want to make sure everyone has a good handle on of what's required. In these last couple minutes, I'm just going to go over briefly workplace violence restraining orders, because again, these changed under SB 553, and I want to make sure everyone's aware. One, if you use them as a tool already, and two, if you don't use them as a tool, there are things that you may want to consider in the future. So again, California allows employers to petition on behalf of an employee for a workplace violence restraining order. Now, starting in 2025, the unions will also be able to do so. Previously, I didn't, when this bill came out, I didn't have too many concerns about that, because if you've ever worked on a workplace violence restraining order, it's a heavy lift. There's a lot of information that has to go into it. There's a lot of forms. It can be expensive. So if the union wanted to take on that role, I didn't necessarily have a problem with that. However, we're going to talk about in a minute that there's been some additional amendments to this law as well that gives me a little bit more hesitation. Now, as part of the law, an employee can also decline to be named in this filing. And if you want to talk about workplace violence restraining orders offline, feel free to reach out to me. You know, Andrea and I do a lot of them, so I can give you a lot of the pros, and we can both give you a lot of the pros and cons to filing one. But one of them is that, you know, a lot of times employers, you know, feel the need to do one, but the employee is not on board with doing it. And so there's a lot of considerations in weighing that. Here, now there's an affirmative right for the employee to decline to be a part of it. But that does not prohibit the employer from getting a workplace violence restraining order on behalf of other employees. So kind of at the end of the legislative session, SB 428 kind of snuck its way in, and then it got kind of combined with SB 553. And what this does is that it adds, so currently you can only get a workplace violence restraining order if there's been violence or there's been a credible threat of violence. And that threshold's pretty high. And that's why I've never really had an issue with kind of bringing the unions into the fold, because most 9 times out of 10, there's not a whole lot of disagreement about what rises to that level between the unions and employees and the employer. But now under SB 428, employers and the unions can now get a restraining order against anybody that is harassing an employee. And what concerns me here is that, which is great for employers in one sense, and this kind of stems from a case that happened at a bank in San Jose a couple of years ago, where a customer came in and was, I would say, verbally abusive to an employee, calling them names, being loud and disruptive, wasn't necessarily threatening, you know, saying things that were threatening or physically threatening the employee, but was certainly harassing the employee. And the employer went in and got a workplace violence restraining order, and the California Court of Appeals turned it over and said that that didn't rise to the level of a credible threat. So that's why we now have this in here, which is, again, great if you have those harassing situations that you need some relief for your workplace and for your employees. My concern is if you're in a unionized workplace, if the union feels that maybe one of your supervisors is harassing your employee and they go to get a restraining order, and now you have a situation where you have a restraining order that needs to be in place in your workplace, and there may be a disagreement about the harassment, whether it's taking place, things like that, and it could be very disruptive. And remember, for a TRO, notice doesn't have to be given. TROs are done on the papers. And so you, employer, may not know that a union is going in and seeking one until you are served with it. So that can be slightly problematic. So that is kind of the sum of SB 553, what to expect. Again, compliance dates for all of this is July 1, 2024. So I know that seems like kind of far away, but in reality, it's going to take you a month or two to put together your program, a month or two to get training together. So really, you know, it's not as long of a period that you think it is. We at Common ACL Carry have been working with a lot of employers, and we have different solutions. We have different services to help employers with compliance. So if you need some assistance, please reach out to Andrea or I, or there's a QR code there that you can scan to learn more, and we are happy to help anybody with that. If you want to know, we also have some webinars coming up that get into workplace violence a little bit more and some other Cal Ocean topics. And we also have a blog. If you subscribe to it, that's where we include all of the updates about the various laws. And with that, if there's any additional questions, please let us know. We're happy to take some questions.
All right, so there are only a couple questions here. First one is, how would this work on a construction site where there are workers from multiple employees working in close proximity?
Yeah, that's a great question. And so that's where that coordinating with other employers element of the plan comes into place. So you're going to have a plan for your employees, and then you're going to have to coordinate with the other employers to ensure that everyone's kind of on the same page in terms of procedures. If there's certain, aspects of security or response, maybe let's say the GC is taking on or things like that. Those are all the things that you're going to have to coordinate as part of this law.
So I see that this is very California specific. Do you see it being implemented in other states, or there talks of implementing that?
So, we've certainly seen an increase in interest in workplace violence prevention and response throughout the country. New York has a similar bill that's moving its way through the legislature right now. That one is mostly geared to retail, but I think now that California has this out, I think we're going to see other states pick it up as a blueprint and incorporate it in other places. So currently outside of New York, I don't think that there's any pending regulations or laws, but I certainly anticipate that this is something that's going to pick up steam. And of course, Fed OSHA can always cite under the general duty clause. We don't see a lot of that outside of healthcare, but Doug Parker, who is the head of Fed OSHA, used to be the head of Cal OSHA. He worked on the rulemaking of workplace violence when he was here, so he's certainly aware of it. He knows how it works. So, long story short is I do anticipate that this is going to be something that we're going to eventually see kind of cascade, in other places.
Do you see that this is a connection between a lot of the mental health awareness that we've been seeing and companies and connecting the two?
It's certainly a component of it. I think that, we've seen a lot of OSH agencies start to do more and, have more considerations around the healthcare space. I think that it is in large part a rise in some horrible workplace violence incidents that we've seen in the past several years as well.
And last question here, there's a mention of documented inspections for potential workplace violence. What would that look like?
So you have to do initial evaluations of workplace violence hazards, and then you have to do periodic inspections. So this is going to be kind of similar to how you do a periodic inspection for any, safety hazard in your workplace. And so, that could be, walk-arounds for physical, reviewing for physical hazards, do all the locks lock, do the key card swipes work, do security cameras work, things like that. It could be reviewing, previous incidents. It can be, speaking to employees about, what are the potential hazards that they see in their workplace. Andrea and I, Andrea mostly, have been doing a lot of work around kind of developing those inspection checklists and to assist employers in those types of inspections.
Thank you. So on behalf of AWCI, we'd like to thank our panelists, Rachel and Andrea. Thank you, attendees, for joining us today. Please join us on March 12th at 1 p.m. for our next webinar, Atlas Accountability, Pipe Dream or Possibility with Kelly Riggs. And you can register on our website, awci.org. Again, thank you, Rachel and Andrea. Have a good day, everyone.